looks like he dropped off, so we
Yes.
probably can proceed.
Hey, counsel, would you please join us on camera? I think Mr. Sheeran is talking to his client.
Yeah, I think we're situated.
Okay, great. Thank you so much. The Court of Appeals is now in session.
And welcome to the virtual Court of Appeals. The case we're going to hear now on today's calendar is Whittison versus Whittison. I'm sure you all have had by now many experiences dealing with the virtual universe, so I won't go over every ground rule, but just to remind you that if we do have a question, that we'll raise our hand, and if you are too deep into your notes or otherwise don't see us waving at some point, we might interrupt, but we'll generally try to wave. I see 12 minutes on the clock. So Ms. Nelson, does that mean you'd like 3 minutes? And very good.
Thank you.
Are there any questions before we proceed? Very good. Then we will ask counsel to mute your microphone and your camera on the opposite side he is arguing. And other than that, you may proceed.
Thank you, Your Honor. Julie Nelson for Appellant Nicole Banks. I understand we may need to talk about preservation, but I'd first like to look at the legal framework that we're operating under. For over 40 years, this court has required both a change in circumstances and an analysis of the best interest of a child in order to modify a decree. That there are contours, but that is not a controversial proposition, and there is not a case out there that says otherwise. Mr. Whittison has argued here that a change in circumstances is not necessary when we're moving from a sole custody arrangement to a joint custody arrangement. And the reason he argues that is because I admit that the statute does not actually say it, but the case law still requires it. Additionally, policy still requires it. And we have two cases, one from the Supreme Court and one from this court, Doyle in the Supreme Court in 2011 and Stevens in this court in 2018, both applying the traditional change in circumstances analysis to a sole to joint arrangement. In fact, Doyle even quotes the typical joint change in circumstances statute and then proceeds to apply it. If Mr. Whittison were correct on this point, it would mean not only that this case doesn't need a change in circumstances, but that no sole to joint arrangement needs a change in circumstances. And to be clear, yes.
I'm sorry, finish your thought and then I've got a question.
Oh, well, to be clear, he's not limited his argument to stipulated decrees, which I understand are also a different contour. He's talking about all sole to joint decrees, which would essentially turn a petition to modify into just a ongoing Rule 60b-6 forever, that you don't need any basis. You can just bring it when you feel like it.
All right. Okay. The question I have about that, Ms. Nelson, is I understand how that argument works with respect to the physical custody determination here, which was clearly set forth in the original decree. The part of that I'm trying to think through is on legal custody. If I've got it right, the original decree doesn't establish legal custody at all. Is that, do I have that right?
That's right.
Okay.
It establishes joint custody for the older child, but it is silent.
On the younger child, right. So if it's silent about that, and then I look at the statute that we all, I think, agree applies, which is 30-3-10.4, and the language that it uses is that if we're going to modify, quote, modify or terminate an order that established joint legal custody, you need the change in circumstance. Here's my question for you. If you have an original decree that doesn't establish joint legal custody at all, then why would we need a change in circumstance? Why wouldn't the better answer be that when the trial court sees that there's a gap, something that was left unsaid, it can just go in and fill that in the first instance? Why isn't that the answer?
Well, I have two answers to that. The first is that if we look at the other contours of the decree, I think we can see that the intent was that mother would have sole legal custody, and the parties always operated that way. And it was never argued that it should be different than that. We can see that mother had final decision-making authority. She had all the tax benefits every year. All of those things indicate that that was the intention of the parties. But even if we treat it as that there could be a gap there, then that still doesn't change the physical custody or the parent time provisions, which were also changed as well. Does that answer your question?
It does, but then why wouldn't the answer be that we'd really have to bifurcate the analysis here? Why couldn't we just say that, at least as to joint legal custody, the court doesn't need to change in circumstances here because it was doing it for the first time, and then we'll deal with the change analysis for the physical custody. That
may be what needs to be done here, but that would only affect the legal custody.
The legal custody, right, and also the child support, I think.
Yeah, potentially. But the physical custody and the parent time certainly were part of the decree. And so a change of those would require a change in circumstances.
Okay. As to the physical custody part, you alluded to this in the beginning. Let's just go ahead and go there. The other side claims that you didn't preserve this below. What's your best response to that?
All right. So I think that we need to look at the preservation issue along with the merits. I think that they really are twisted together. And so what I want to do is sort of walk through the parts of the record where the merits were discussed, which also gets us to the preservation. And when I say the merits were discussed, we will see that Mr. Whittison has never presented that change in circumstances. Those really go together. And before I do that, I want to point out that this case is a braid, is the way that I look at it. We've got all these different strands that came together and really got braided together. There was the relocation issue, there was the paternity issue, and the one that we're focusing on here is the change in circumstances regarding the husband, his physical custody and his parent time. So focusing there. Let's start with his original petition to modify. That's record 450, where he says there has been a significant substantial material change in circumstances. He doesn't articulate what it is. The next sentence says, since the time of entry of the decree of divorce, petitioner and respondent have exercised approximately 50-50 custody of both minor children. Now, we disputed that that was true, but regardless, that is not a change in circumstances under Krauss. So he hasn't articulated one there. In our answer to that document at 482, we say, respondent's verified petition to modify decree of divorce should be dismissed based upon the fact that he has failed to provide sufficient substantial material changes, which were not foreseeable at the time the decree of divorce was entered. The commissioner then makes a recommendation, and we object to the commissioner's recommendation at 677, and we say, petitioner objects, the commissioner improperly found that the parties had made changes to the existing order, which warranted ratification by the court. That document then becomes the basis of a hearing, and this hearing is key, and I encourage you to read the entire hearing. It's about 50 pages long. It starts in the record on 1607, and I think that when we read that hearing, we can really see what happened. So I want to point to a couple of provisions of that hearing, but I also want to talk about what I think the trial court thought. So we know that it was raised to the trial court's attention on 1610. He says, I don't know if the commissioner has agreed that there's been a substantial and material change in order to justify the petition to modify. Can you give me background on that? And then on 1611, he says, what was the basis of the substantial material change in circumstances? And we start saying that, well, we're now talking about the other side's petition to modify. And we say, well, I understand that it was as a practical matter. And then it talks about, it kind of loses track. And then comes back on 1614 to say, we go forward on 1618 where the judge says, I'm sure the parties' behavior and any decisions that they make in their lives that aren't specifically addressed in the decree clearly do have an impact or a potential change in what is listed or impacted in the decree. So that's the trial court giving its first hint that it thinks that the party's behavior, by which it means the way that mom has exercised her discretion, qualifies as a basis for a change. I said a minute ago, but it's still true that under Krauss, that's not the case. If we go to 1626, The judge says, what other change of circumstances do you believe are appropriate under either petition? For example, this is to the other side. This is to Mr. Whitison. For example, do you agree with counsel's suggestion that their argument that her anticipated move would blah, blah, blah? And then the other side says, no, Your Honor, I don't agree with that, talking about the relocation, and then never answers the question, never presents another substantial change in circumstances.
Okay, can I, unless one of the judges has a question on preservation, then with given time, can I take you to the merits on that question?
Yes.
Unless we want to stay there. Okay. Here's the piece that I'm struggling with. It's the Krauss concept that you've talked about. What happens if you've got a custodial parent who allows non-custodial parent over the course of multiple years to develop a relationship and then unilaterally decides not to? Why can't a court why can't a district court look at that and say, you're severing a bond that you allowed to be created, and that bond itself that didn't exist before, that exists now, that's the change in circumstance. Before, when we did the decree, you didn't have 8 years of parent time. Now you do. Now the kid thinks that this is dad. That's the change in circumstances. Why isn't that the rule, or why isn't it the better rule in this circumstance?
Because when we look at what the decree provided, it provided that mom had sole discretion over parent time. That doesn't contemplate that she's never going to give parent time. It contemplates that she might, and she has discretion to do that. And when we look at the record sites that Mr. Whittison has provided in his brief, he cites to 1370 and 1371 as his change in circumstances. All he's doing is saying that he doesn't like how she's been exercising that discretion. But I think what we see here is Mr. Whittison trying to say he's changed his mind, not that there's a change in circumstances. And that is not enough. We can't just have a stipulation that years later, people are like, I don't really like how that's playing out. That's every divorce, right? I'm not happy with how that's working.
But isn't there some suggestion in this record that she had allowed him to have a very healthy amount of time with the child, and then over that 6-month period toward the end, she had said, no, I'm gonna pull that back?
Yes, but she had not had as much time as Mr. Widdison had argued, but that didn't really get to be fleshed out at trial fully because we moved on. But she had a relationship with him, and then she pulled him back because she felt like that relationship was damaging the child, which she could do under the decree, right? She's exercising her rights under the decree to pull that back. And so again, we don't have a change. What we have is her enforcing the decree. So a change in this context would need to be something like she's abusing or neglecting the child, or the child is somehow in danger with her. But when the decree says she has sole discretion over parent time and she exercises it, that's not a change. That's the same as like letting you go to your aunt or your uncle or your grandparents for a long time.
It is, but it isn't. I mean, there's sort of like a tomato thing here. On the one hand, you're right that the original decree contemplates that she's going to have this sole control over how much time father or husband gets to spend with the child. But then on the other hand, you've got the lived experience. You've got multiple years, whereas before a child had not bonded with him, and now you've got 7 years of child bonding with him. And so suddenly, if the whole point of this change in circumstance doctrine is to preserve stability for the child, now you're taking a father relationship that didn't exist before, but does exist now, and you're taking that away. That seems to be the opposite of what the doctrine is designed to
But that is Krauss. That's exactly what Krauss says. First, the fact that Mrs. Krauss has been generous in sharing physical custody with Mr. Krauss is not a ground to change physical custody. If anything, it supports leaving primary physical custody with Miss Krauss, as it shows she has lived up to the responsibilities of a custodial parent. And that's what Krauss says. So Krauss says that, and the decree says that. Judge Hagan?
I have a question for you. I'm not sure why and I understand what you're saying about the adjudication of parentage, right? That he was the presumptive father all along, so that technically wasn't a change in circumstance. But as I understand what the district court did here, one of the things the court said was, I really should have never entered this stipulated decree, because not only did it not address these issues with respect to this child, but it didn't give him any responsibilities like child support and that sort of thing. Although I understand that there was some obligation to pay for medical insurance and preschool. But once the court is correcting that omission and imposing those responsibilities on the father, why wouldn't that be a change in circumstances that would allow the court to also grant rights to go along with those duties to the father?
Well, to be clear, the decree did have a physical custody provision and it did have a parent time provision, right? So those were not omissions that needed to be corrected. The legal custody may be different, but that's not an omission. And so when the trial court years later looks at a decree and says, I don't like that, I wish I hadn't entered that, that's like a sua sponte petition to modify. That's a motion to set aside my own decree. That's not what the case law allows. Otherwise, decrees could do that all the time. The judge could just look at the decree and say, I wish I hadn't done that.
So the court can never just reconsider an order where they have continuing jurisdiction?
Not without a change in circumstances. Yeah, not without a change in circumstances and not without, in this case, looking at the best interests of the child. I mean, if that were the case, it could be true of alimony. It could be true of anything where the court has ongoing jurisdiction. So, no case has said that the trial court can just decide it doesn't like what it entered and change it. That just gives the trial court ongoing 60v6 power. That's not.
But specifically with respect to the court saying that the one thing that the decree omitted that it should have included was child support obligations with respect to the second child. Once the court finds that and imposes that, why isn't that a change in circumstances that could allow the court to also give the husband the duties, or the father the not just the duties with in terms of support for the child, but also the right to parent time with the child?
That's because they're not related. The parties had reached the stipulation that they agreed was in the best interest, that mother would have sole discretion over parent time, and that she would have sole physical custody. And, our argument has been sole legal custody, and that happens. Even adjudicated parents who do have a child support obligation, there could still be sole physical custody with no or limited parent time. There can still be sole legal custody. So there's, that's a scenario that can exist. The trial court could have found that in the first place. It didn't need to, because the parties had agreed to it and the trial court approved that. So changing one piece doesn't open up all of the other pieces. There are no further questions. I will reserve for rebuttal.
Very good. I look forward to seeing you at the back end. Mr. Sharon?
Thank you, Your Honor. This case is about Bryant trying to get basic rights to his non-biological son, EW, by changing a decree that failed to give him those rights. In simple terms, all Bryant wanted was to treat his biological daughter and non-biological son the same. Accordingly, Bryant filed a petition to modify, and the court granted Bryant the same rights for his son as he did his daughter. Before getting into the merits of the appeal, there are two dispositive issues that the court must resolve. One, whether the change in circumstances required element when a parent seeks to modify a sole custody order. And two, whether Nicole preserved this issue for appellate review. For the custody...
Can I start you with a question on that first piece? Let me first make sure that I got your argument right. If I'm getting it right from the brief, you're relying really heavily on the language of 30-3-10.4 subsection 4. And as I understood your argument from your brief, your point seems to be that because that particular sub-provision doesn't contain any language about change in circumstances, then it just doesn't apply when we're moving from sole to joint. Is that right? Is that your argument?
That's correct.
Okay. One of the things I noticed when I'm looking at that statute is that particular sub-provision also doesn't say anything about a best interest analysis. So if you're right that we're going to take that sub-provision on its four corners, then I think you'd have to be saying that when we're moving from sole to joint, a district court also doesn't have to look at the best interest of the child. Would that be your position?
No. So in my brief, I also cite to the provision in Utah code that states that any custody order
So
needs
that's
to
how it is, yeah.
include the best interest of the child. So while it's not contained in section 10.4, it is contained, I believe it's 10.2, which you have to look at both of those when you're looking at changing any custody or entering for the first time any custody order.
Okay, so even with that is the answer to that part of it. Why is it the better reading of subsection 4 that it's just simply an additional requirement? You've got this earlier language in subsection 1, which sets forth this analysis for modifying, and it requires a change in circumstances. And then we come to subsection 4, and it says, if we're moving from sole to joint, the party shall file and serve a proposed parenting plan. Why isn't the natural reading harmoniously that this is just an additional requirement in the sole to joint scenario, as opposed to setting forth an entirely different rubric?
That was something that it looks like the legislator contemplated. They could have easily added the word sole to subsections 1 through 3, but they chose not to. If they wanted a change in circumstance and for all the requirements of changing a sole custody order to be followed, they could have easily done so, but they chose not to. So in 2005, when they added subsection 4, which is formerly subsection 2, they didn't include that provision. From listening to the House hearing, it states that, in fact, the court has even authorized and directed in the code to ascertain from time to time to the extent to which a parent is willing to love and accept and encourage involvement with the other parent in the child's life. So it's some simple language that makes the code internally more consistent, and that it hasn't received
right. But if making it internally consistent is the goal, then it seems that your position would undermine that, because if you agree that when we go from joint to sole, and you'd have to, the statute says this, when we go from joint to sole, you've got to have a change in circumstance, and we've got this mountain of case law that says that the reason for requiring a change in circumstance is to prevent ping-ponging with the children, to create stability and so forth. If we then turned around and accepted your position and said that when we're going from sole to joint, you don't have to have a change in circumstance, then it seems like we'd be creating a scenario in which children would be ping-ponging in those cases much more easily, which is the thing that all those cases says we're supposed to not be doing. So now we've got an inconsistency, don't we?
Well, I don't know whether it's an inconsistency in all cases, but in this case, it wouldn't be. Any of the policy considerations of the reason for a change in circumstance really don't apply in this case. Both the ping-ponging and the other two that apply. I think there could be an amendment to this section that clarifies how to change a sole custody order and whether or not a sole custody arrangement needs a change in circumstance. Really, the only difference between changing a joint custody order and a sole custody order is proving a change in circumstance or not. The legislator stated that they want to encourage parents to be involved, and I think that's maybe why they didn't include that change in circumstance requirement for the sole custody change. So another issue is the preservation issue. The preservation, it's the appellant burden of establishing in its opening brief where each issue was preserved for appeal. You heard opposing counsel go through a hearing and other things, which brings me to an issue that preservation in an opening brief versus a reply brief. On appeal in Nicole's opening brief, she only had one single citation in the 2000 plus record that this issue was preserved for appeal. The citation was to her answer in response to Brian's petition to modify. Only after we pointed out the lack of preservation did Nicole in a reply brief cite to other potential areas in the record to rectify this issue. This secondary attempt, however, is futile since an appellate cannot argue preservation or an exception to preservation in a reply brief. You can look at State v. Howell, the 2016 Court of Appeals case that states, but in dealing with preservation in the reply brief is too late. We have consistently refused to consider arguments of plain error raised for in the first time in an appellate's reply brief. even if the plain error argument is in response to a dispute over preservation raised for the first time in the appellee's brief. Also in Marcroft, a 2015 Court of Appeals case states, quote, "This is not as unfair as it may sound. After all, the appellant bears the burden of establishing in its opening brief where each issue was preserved for appeal. And if an issue was not preserved, why it should be considered anyway, such as because of plain error doctrine applies. An appellant proceeds at his peril if preservation or plain error was not dealt with in his opening brief. So I think all these additional areas that Nicole is now arguing in a reply brief and today aren't preserved. She waived those by not including that in her opening brief. So then you look at what was in her opening brief. There's really a single citation, and as stated in my brief, the mere mention of an issue in the pleadings is insufficient to raise an issue at trial and thus insufficient to preserve this issue for appeal.
So is your argument that she should have filed a motion to dismiss his petition because there was no change in circumstances, or he had not pled or could establish a change in circumstances?
As it relates to Bryant's petition to modify, I think she could have done a motion to dismiss, motion for summary judgment.
Okay. And was there also an option to raise that issue at trial?
Yeah, they could have certified one of the issues, whether or not there was a change in circumstance warranting modification, but they didn't. I mean, this issue was not even argued at all throughout the proceedings. And you got to ask yourself, why was this not argued in the lower court? And the answer is fairly simple. Nicole was too busy arguing that Bryant had no rights to his son. Specifically, Nicole argued from the time Bryant filed his petition to about a month and a half before trial that Bryant had rebutted his parental presumption, giving him no rights to his son. Once that argument failed, Nicole modified her argument and argued that Bryant's rights were not parental rights.
But when we asked Ms. Nelson that question earlier, one of the things I wrote down in my notes that she said is that in her answer, she specifically said that there had not been a change in circumstances. So was that correct as a matter of record? And if so, why isn't that enough?
I think she was referring to an objection to, I can't remember if it was the motion for temporary orders. I would need to go back and check, where she just kind of alleges that, among other things, her main argument being that he had no rights to his son. There might have not been an issue, or there might be an issue.
But if the point of the preservation rule is that a party simply needs to bring it to the court's attention so the court can rule on it, and even if you're right that this wasn't the thrust of her argument, I mean, Ms. Nelson quoted multiple places where counsel invoked the phrase and said to the court, hey, there's not a change in circumstances. Why isn't that enough to at least bring it to the court's attention that they think that this is a standard that has to be enforced?
Two thoughts. First, all these statements were in Nicole's reply brief. They weren't in her opening brief. And I don't think based on
the appellate waiver argument here, right? The preservation.
Right. The second thing is that these arguments were made well before trial. By the time they certified issues for trial, a change in circumstance wasn't one of them. And State v. Johnson, it states a party may waive an issue by relinquishing or abandoning it before the district court, either expressly or impliedly. And I think that's the case in this appeal. Nicole impliedly waived the change in circumstance argument. She could have easily certified one of the issues for trial. Now, in a reply brief, she states that that the first certified issue, which was whether Bryant should be awarded joint legal and joint physical custody of both minor children, quote unquote, has meaning behind it, and alleges that the change in circumstance might fit underneath that argument. But that's just not the case. And my response is twofold. Being awarded joint custody is a best interest analysis. That's section 10.2. So in that first certified issue, that's not hey, we have a change in circumstance issue, we need to address that. This is what's in the best interest of the child. Second, if the first certified issue had meaning, then Nicole should have, but didn't argue Bryant's petition did not prove a change in circumstance warranting modification. Arguing a change in circumstance on this appeal is introducing a new theory, a theory that was not factually, procedurally, or legally developed in the lower court.
Can I take off preservation just with the few minutes you have left? Can you respond to the Krause argument? I mean,
yes,
you heard my discussion with Ms. Nelson. There's this question. I think your client's best argument is, look, I had multiple years of bonding with the child, and now she's trying to sever it. That's the change in circumstance. But Ms. Nelson points out that under Krause, we seem to say that that can't be the change in circumstance. And then in her brief, she also relies on Doyle, which seems to say it's got to be about the custodial parent, and that's not this. Could you respond to that?
Yeah, the Krause case is for when a custodial parent gives up some additional time to the non-custodial parent. In this case, with the opposing counsel's argument, then that would never allow for a change to occur. For example, and I'll give it a little bit more extreme circumstance. Let's say the custodial parent gives the non-custodial parent more parent time, more than 50% to the non-custodial parent, and does that for years. And so that person, that non-custodial parent, is paying child support for that entire time, even though he might have 30-3-35 rights every other weekend, one midweek visit. In that case, you are just correcting to what the parties are doing in actuality. And I think that is the case here, is they have been exercising parent time. The arguments was 50-50, 40-60, something like that for over 7 years and continue to this day.
But the other side's response to that is, right, but they're doing so under the rubric of an order that gives her unilateral control over time. I mean, the order really...
And under that argument, I give up my rights and let one party decide, you could never change physical custody unless, like the opposing counsel alleges, unless there's some type of abuse, which I don't think that for an unadjudicated decree where the change in circumstance is a particularly low ebb, I don't think that should be the case because...
But staying on the terms of their argument, I mean, I think she's making a narrower claim there. She's saying, look, if we, the Court of Appeals, come out now in this case, and we say that if a custodial parent gives a lot of time to the non-custodial parent, and that can then be reason to change the custody decree, that what you, the divorce lawyer community, are then going to say to your custodial parent clients is, don't give him any time because otherwise you're going to lose your rights. And so she shouldn't be penalized for being a good parent for those 7 years. I think that's her response to that. So,
sure, I understand that. Let me point, since I'm limited on time, that Nicole also alleged a change in circumstance in her amended petition to modify, requesting that Bryant be given physical custody of both children. Specifically, Nicole requested that Bryant have visitation with, quote, the children in accordance with the relocation statute 30-337, or in the event Nicole does not relocate, Bryant having visitation under Utah Code 30-3-35. Nicole herself is requesting in her own amended petition to modify that Bryant be given physical custody and parent time in accordance with the statute, which he ultimately ended up getting. And now she's appealing it, which to me makes no sense. And in fact, her trial transcript said, her attorney asked, if the court's decision is that you can relocate and that you can take the children, that your parent time schedule, are you willing to pay for these monthly weekends for the children to be back in Utah? She answered, absolutely. Another question, do you have any concerns about sending the children back?
Do I have it right that the provision you're relying on is about parent time as opposed to physical custody?
Yeah.
And I think there's a difference under the law, unless I'm mistaken. Correct me if I'm wrong on this, but I think we've treated those two differently. We've said that physical custody is not synonymous with parent time.
Right. Parent time, physical custody is based on the amount of overnights you get. Parent time, I think, is the facilitator of that. It lays out the nights and weekends and all that stuff.
So why would it be legally inconsistent for her to say, yeah, I agree that he should get some more nights, but I'm not willing to agree that he gets physical custody with all that term entails? Why would that be inconsistent for her to take as a position?
I think it's inconsistent because she didn't specify in her amended petition that she did not want Bryant to have the physical custody, that she alleges that, yeah, he can have physical custody and this is the parent time that I think he should get. And ultimately that's what the court did. And so that among Bryant also alleged a change in circumstance and that there were a lot of issues with, the court is allowed to fix unworkable decrees, significant issues. I think the court easily saw that Nicole having sole custody of the minor child that's different than the older child, and the only difference being is one's biological and one's not, is creating significant problems. Brian testified to that fact. Nicole didn't even rebut that at trial. So I think that if the court finds that the Utah code does not require a change in circumstance in this case, that Nicole did preserve her appeal, I think the court can easily find that the judge was warranted in doing so. Judge Hagan pointed out that when you open up one area, the court has said in Boyce v. Goebel 2000 Utah Court of Appeals case, a change in circumstance may justify reconsideration of of more than one provision. This concept is especially true when the areas are interdependent. For example, child custody and child support, while governed by separate statutes, are typically related to one another. In fact, a child support award under the guidelines is statutorily predicated on the time the children are in custody of each parent. So I think that in and of itself, child support was absent, legal custody was absent, and the physical custody was a bad physical custody arrangement for the children. All those facts show that the court was easily warranted in changing the circumstances to modifying the order to be something that is in the child's best interest.
Any other questions from any panel members? See no takers. Mr. Sheeran, thank you for your presentation, and we'll turn back to appellant.
Thank you, Your Honor. I have just a few points. On the preservation point, it sounds like Mr. Whittison's complaint is that I didn't have a long list of sites on the page of the opening brief where you're supposed to list the preservation sites. That is not my understanding of the preservation rule. My understanding of the preservation rule is whether the issue was brought to the trial court's attention, and it clearly was. One of the things that has been missed here is that the trial court made a finding about change in circumstances. The trial court knew that change in circumstances was one of the requirements. It asked about it several times at the hearing that I cited, and it found that there had been a change in circumstances. It just didn't say what they were. And that's, the problem. Had the trial court made a finding about change in circumstances, this appeal would look different. We'd be arguing about whether that was supported or whether it was fair or whatever. But the trial court didn't say what it was, and our position is that on this record, none has been alleged. I'd like to
when you have both parties filing petitions to modify, alleging that a change of circumstances has occurred, why can't the court treat that as undisputed, that there has been a change of circumstances?
That's a great question. It's important to recognize under Ross that mother didn't need to file a petition to modify regarding the younger child. The commissioner instructed her to do so, but she didn't need to under Ross. That commissioner's ruling was incorrect. Now, she may have needed to do it regarding the older child, but under Ross, when a sole custodial parent has sole custody and they want to relocate, they don't have to file a petition to modify. So I think we put mother in a box here that she can't get out of by saying, listen, you're going to need to file a petition to modify, even though the case law says you didn't. Oh, well, now that you filed a petition to modify, then you've, conceded that there's a change in circumstances. That's not how this pathway is supposed to work out. So she didn't need to file that. She did it provisionally, and it's clearly labeled provisional, but it was unnecessary regarding the younger child. The only change in circumstances, even now, that Mr. Whittison has alleged was the first thing he said and the last thing he said. The last thing he said was that the physical custody arrangement and parent time was bad. That's not a change in circumstance. That's saying I changed my mind about what I agreed to. And that's the first thing he said as well, which is that he only wanted to have a relationship with his older child the same as he did with the younger child. Well, that was presumably true even at the beginning, even when he signed that stipulation.
So is there a foreseeability component to the change in circumstances? I mean, it sort of seems like there's shades of that in your argument. That if the original decree said something and there was something foreseeable that were sort of locked in place from what it was at the outside, or am I reading too much into your argument?
Well, it's a longer question than I can answer in 0 seconds, but the statute doesn't require foreseeable the way that like the alimony statute requires foreseeable or used to require foreseeable. And I guess there's an argument here that the statute doesn't require it at all. The case law doesn't really talk about it. There are a couple of places, more like in the 90s, where they kind of dropped it in, whether it was foreseeable. But maybe you can help me understand more what you're saying. I don't really see that as being part of the question. The question is, was it a change? So we know that we've set this up. We know that we've said that mom can have sole discretion over parent time. And there's a part in the record that I can't find now where husband testified that he agreed to that because he thought that she would follow the same schedule. Well, if he thought that, then the foreseeability doesn't even matter at all because that's what happened. She did that. And then later on, when she felt like that wasn't working out anymore, she exercised the discretion that she was given in the decree to hold back parent time. And, Judge Tenney, you indicated this during your conversation. If we say, a parent has sole discretion, she exercises it. Oh, that's a change in circumstances. That's not going to work for future cases. We need to say we've got the terms of the decree. They are XYZ. If the judge doesn't like it, the time to change it is at that time when it's signing the stipulation, not years later. Years later, the only thing that's on the table is whether there's been a change in circumstances, not a change of heart. If there are no other questions.
I actually had one. It's kind of a follow-up on Krause. I believe when you were talking, responding to a question earlier about Krause, you said it would be different if there were allegations of abuse and that abuse could constitute a change in circumstances. And I think we all recognize that even under Krause, if what you had was a certain set schedule, but the parent with custody was interfering with not even following the schedule that was there, that would be something we could do something about. And I think we all recognize the wisdom of what Judge Tenney referred to in saying that we want to encourage parents to facilitate relationships with other parents. And we certainly wouldn't want to do something that would make all domestic lawyers advise their clients don't give them anything because then that's going to be held against you. But taken to its extreme, maybe 8 years isn't enough. But if, let's say, 12 years, there was this relationship that gets formed, and then a parent, because they have discretion in a decree that was entered 12 years ago, completely cuts that off, is there any room to argue that at some point that becomes abuse?
Well, that has not.
Thinking of the kid, right?
Yeah, right. That has not been alleged. To be clear, that has not been alleged. I was throwing abuse or neglect out of something that.
I'm not saying it has been alleged. I'm just asking the question.
Okay. Yes, I don't know. I don't think that exercising your parent time under the decree counts as abuse. And we do have in Doyle, one of the changes that had been argued was about one parent, not allowing the parent time that was required. And the court had found that if you're not providing the parent time that you're supposed to, then the other side's remedy is an order to show cause, not a petition to modify. So the law has a provision for that. Now, you couldn't do an order to show cause where she's exercising her discretion. But again, we don't have a change. The other things that you talked about go to best interests. But the case law is excruciatingly clear that there has to be a change. You can't skip the change step and go straight to best interests. So I was then trying to come up with some scenarios where a change in circumstances could be asserted in this type of case, but none of them have been, and on the record could not be. The trial would look different if that was what we were talking about, but we were not.
Hagan had a question.
Yeah.
I do. I have a follow-up on the preservation question. When I've seen this change of circumstances issue come up in other cases, and I obviously don't have the experience in these cases that you or opposing counsel have, but generally it's a motion to dismiss the petition to modify because they can't, the petitioner can't make a showing that there's been a change in circumstances. And here, there was no motion, so that was never, the court was never asked to rule on that. And then I don't see where even at trial, Mother asked the court to rule on the issue of whether there had been a change in circumstances. And then after the court issued its opinion, there wasn't an objection to the court's finding on that. So I'm just wondering, just putting it in the response to the petition, does that actually raise it to the level of consciousness that the court would rule on that issue rather than assume that it is undisputed?
There's no requirement that you have to file a motion to dismiss or a motion for summary judgment in order to preserve your issue, right? And there's also no requirement that you have to raise it at trial if you've raised it in other places. So that's why I was focused on the objection hearing, the objection to the commissioner's recommendation, where the issue was discussed. It was raised. And the trial court said to the other side, what's your substantial change in circumstances? And the other side didn't answer. And if we follow through what the trial court thought, we can see that the trial court's position really was its own frustration that it had signed the decree. It never finds that a change in circumstances has existed. It doesn't, not only does it not list it, it doesn't say it either in its musings or it gives an oral ruling. And there's quite a lot of discussion about it at that commissioner's, let me give you a date so that we all know what I'm talking about. The September 30th, 2019 hearing, that's the one that I encourage you to read. We can see that the trial court's concern is that it's just frustrated that it signed the decree. But like I said, that's not a change. This is not the time to do it. And but the trial court at that point said basically like, okay, let's move on. And it instructed counsel to issue the certification order after that. And the certification order included the provision that there should be a modification, which we all know means those two things. You don't have to break out the elements in a certification order. We know that's what they mean. So we certify whether there should be a modification, and then we move on to trial. At trial, it was such a rush job. There's no closing argument. There's no opening argument. There's just testimony. And the trial court says, yeah, I don't need to go over this again. That's why when that commissioner hearing, it's not in front of the commissioner, the hearing in front of Judge Faust about the commissioner recommendation, that's where the issue really gets addressed and pulled out. But we also see it, not just in the answer to the petition, we also see it even after that had been raised, then the other side files an amended petition and we point it out again and it still doesn't get addressed. And then the trial court makes its ruling saying there has been a change in circumstances, period. No discussion of what it is. The case law is clear that you need findings. Well, what do you think the change in circumstances is? I mean, at a minimum, this court could remand and instruct the court to make findings, but our position is that that's unnecessary because there was nothing to find.
And would we do that where there was no objection to the adequacy of the findings?
Oh, I think so, because the case law requires that the court needs to do it. I mean, it would have been plain error or the court not to do it. We didn't argue plain error because the issue is preserved. But I mean, the preservation issue doesn't require that you keep bringing it up, right? It's raised to the trial court's attention. The trial court knows there needs to be a change in circumstances. He asks what it is. The other side doesn't assert what it is. We say that's not a change in circumstances, and then we move on. At that point, we're then talking about the best interests. We don't have to keep repeating ourselves. If there are no further questions, we would ask this court to reverse.
Right. Well, thank you very much, Mr. Sharon. If you can join us back, we appreciate your arguments today and your briefing in this matter. We will take this matter under advisement and issue a written opinion in due course. Thank you for your arguments today.
This court is in recess until 11 a.m.